So if you want to understand what is culpable, what is punishable, what is criminal, you should understand whether you have the knowledge while committing it. And second, what is your motive? If the doctor doesn't have these two things, or anybody else has, then 304 is not applicable. It is as simple as that. Now, if I presume, how does 304 come in? For example, I'm a patient, you happen to be operating. We have this interaction here. I have a hot exchange. That gives a motive. Unless the patient and the doctors, they do not have first-hand acquaintances or previous exchanges or previous history where they've met, 304 doesn't come into play.
Dr. Rajiv, I want a practical example of a case where 304 is applied on a medical person.
Doctor, I haven't personally come across 304 by to a medical doctor. If you know a case, I will discuss it why it could be applied. It has been. Otherwise, to my knowledge, I have not come across a case where we applied 304 in the capacity of his discharge of duty as a doctor. Maybe as an individual, yes. If I do something wrong.
Dr. Pawan, can I have one query? See, we all know, I think majority of the senior people here must be aware of a case of Sundarlal Jain Hospital, where the owner of that hospital, one of our seniors, he was arrested in 304 and there was a lot of hue and cry after that. And the case, as far as I remember, was only that the patient was referred from that hospital to a different hospital because of his serious illness, and that too was by the resident only. Patient came to emergency. In emergency, patient was assessed and he was found to be sick, referred to other hospital. And he was arrested and it was made a non-bailable offense. And with all hue and cry, I think, if I'm wrong, Dr. Chaturvedi can remember that case.
Can I? Sir, can you use it for 3 days? Yeah. See, I have also done postgraduate diploma in medical legal systems, and also there is the latest guidelines of Supreme Court. In 2005, Justice Markandeya Kadju has given specific guidelines in the Supreme Court judgment. When a complaint is made against a doctor to the police, then the medical board, the police will not sure to take action against the doctor. The case will be referred to the medical council of the particular district or state, and the medical council will form a medical committee, a technical committee. That medical council will give recommendation to the police whether the doctor is guilty or not. So moto, no policeman can arrest a doctor unless the matter is referred to the medical council. It is the latest guidelines and the judgment of Justice Markandeya Kadju, Supreme Court, 2007 or 8.
This came only.
Sir, I want to say that
I'm aware of this. Let me yeah. This is Jacob Matthew versus.
Yeah, that's right. So whatever the judgment of the Supreme Court judges, it becomes a law.
Sir, what I want to say that in spite of this judgment,
yes,
still 304A is frequently applied on doctors whenever a death has occurred and the doctor was put behind bar. Till now, whenever death has occurring, the 304A is applied without taking any approval from medical board. And recently, during the death of a 9-year-old child, yes, after a minor surgery, the doctors and the anesthetist, they both were charged with 304 in the police station, and later on when they go to the court, it was converted into 304A.
Yeah, that's what I'm saying. You should immediately seek the reprieve. Maybe because you are ignorant, those people who have so far helped doctors, because I tell you, the moment somebody comes to police wala aa gaya, we become very panicky. Now, I have faced a case where, and still probably, I don't know, the case still must be going on. The policeman came to my house. I said, no, I have treated the patient in Shantigun Hospital. Go and break your hat with the medical superintendent. What is your number? I will bring up the police commissioner. He went away. Well, because they want to fleece you, they want to harass you. So it is, therefore your medical association should talk to the medical council of UP, and you cannot go against the law because we are ignorant. Immediately once a doctor is charged in 304, you should immediately go to the court or go to the high court to get a stay and change it to 304A. It can only be done. See how a policeman or an inspector or an investigation officer will know that the doctor is negligent or not. That is what the point is. So if probably you have to make yourself strengthened and make yourself aware, you must have a legal cell in your IMA, Ghaziabad, and take advice from time to time.
Even the doctor has been given more protection in view of this special case.
Yes.
Now, if the complaint is made that the doctor has been negligent enough in treating the patient, then still a further protection has been given that it should be certified by another doctor that the doctor should have done this much. And without that certification, the criminal liability is not fixed, nor even tortious liability is fixed, and ample protection is there. I may tell you my own case as an advocate. I filed a complaint before the consumer court against a doctor. The wife of the complainant fell ill, dengue was diagnosed, platelets were going down. She was not admitted by the doctor in Dr. Bhimrao Medical Hospital. कहते रहे कोई बात नहीं ठीक हो जाएगी, दवाई दे रहे हम, कोई तो ज़्यादा बड़ा नवाब है क्या कि जो तेरी बीवी को हम सबसे पहले बैठ देंगे, and she died. Complaint was filed. My complaint was not entertained by the London Consumer President only on the ground that first get certification from other doctor, how the doctor had been negligent. And ample protection has been provided now to the doctor. They should not nurse untenable concept. As far this my subject, section 304A.
Sir, now this passage is clear that in case of a death, police cannot apply 304A without consulting a medical panel.
Police can, you cannot restrict the power of the police, but they are also human beings, and they will not unreasonably harass a doctor. As far the last part of your question is that whether this is sufficient evidence or proof of negligence, the fundamental principle of criminal jurisprudence is that before one can be condemned, it should be heard, which includes the reading of evidence and proving of his negligence. Without proof of negligence or in the absence of evidence, no case can be justified against the doctor. Even if the police investigates a doctor and finds ultimately that no, this is scanty evidence or there is no evidence, then they are not enemies of the doctor, they are friends of the doctor, they will let him go. Rather they will move before the London court that no, we do not have ample evidence and he will be charged.
The fundamental law of the land is IPC, the Indian Penal Code. And what Supreme Court has said in Jacob Matthew versus State in 2012 was that in certain circumstances where you find that a complaint has been received where a doctor has been alleged that he's committed this crime, in that case you have to seek a formal opinion. Now if the negligence or the matter is such that an offence is made out, there is no deterrence to the police, there is no prohibition that they cannot register a case. It's absolutely clear. Nobody stops police from registering a case. Now what happens is, yes, they should not arrest.
Excuse me. So one point I want to say, as sir said, the 304A can be implemented. If it is, you see, has been imposed on a particular doctor found to be negligent, it needs to be negligent. Whether the doctor can be arrested or not, this is basic question.
I think my friends here, let us discuss about what is 304A. बहुत सारा शोर हो रहा है 304A. Let's see the main ingredients. What differentiates 304 from 304A? Now 304 says that you have the intention and the knowledge and the person gets killed. Now leave it apart. What concerns more to this medical fraternity is 304A. 304A is death due to negligence, a negligent act or a rash act. Now we have to differentiate what these two acts are. And especially when you're referring to the medical negligence cases. Now what is a rash act? An act is called rash when it is reckless. Meaning thereby that you know that what you're doing, you're absolutely clear on what you're doing. You also know, you're very conscious about what are the adverse effects or what are the likelihood, the consequences of this surgery or of the medication that are given to the patient. Second. And the third is that you still hope, it's a good wish, you still hope and you're hopeful that this may not be true. In this particular case, normally it could happen. But जो आप जिस मरीज को ठीक कर रहे हैं, आप सोचते हैं इसमें नहीं होगा, अगर होगा तो I will tackle it. This overconfidence, I will say, is rash act. What is a negligent act? A negligent act is a smaller version, a simplified version or a lesser version of this rash act. It is again, you have the knowledge, you are conscious about your acts, you know what could be the negative aspect, the consequences or contraindications or whatever, complications of the procedure, but then you fail to perform your duty. That there's a clear-cut breach in what you do. So there's absolute clarity. Let us be very clear about what is a rash act and what is a negligent act. Be that as it may. Now what happens is whether it is a rash act or whether it is a negligent act, the section of the law is the same. The punishment is the same. So forget that. Now what happens? 304A comes. Now how does the court, the police can only register a complaint, it can investigate. Now finally when we investigate, investigation is nothing but collection of evidence. What we try to prove is whether what A has said is truthful or it is false. So in support or against the complaint, we collect evidences, we collate that systematically and then produce it before the court of law. Then the court will decide whether to take cognizance, whether the material available on record is sufficient enough for us to apply our mind. If that is not the case, then they discharge the patient then and there itself. Not the patient, sorry. The accused or the alleged person. Now, in 304A, when a complaint comes, you are collecting the evidence, and during that time, police will definitely consult doctors. It doesn't happen that a non-technical person, because we get cases, for example, income tax fraud or any other fraud other than conventional crimes. So we always refer to the experts, and so that's not a case that we don't refer. Where you are contradicting is whether we should do it before registration of the FIR or thereafter. So that is one thing where I think the police also needs to be educated. Not everybody knows what is Jacob Matthews versus Day. So that is one good point that I pick up from this conference and I'll take it back home. And one more thing I would like to add is beyond negligence and the rash act, what is important in 304A is that ultimately when a person dies, the subsequent action which a doctor takes also tells what is being serious. Normally a medical fraternity, gets into the clutches of the law because of his subsequent actions. Let me tell you, I've come across 3 or 4 cases. In all these cases, whatever doctors do to manipulate the record fixes it. Don't ever do that. Aapse mareez mar gaya, you have intentions. आपकी गलती हो सकती है, again it is not negligence. See, the Supreme Court says, the law says 304A में if आपसे अगर गलती हो गई है, if it is a genuine error, judgmental error is acceptable, manipulations are not. If you manipulate, you're caught. It is documented. You cannot escape. And once it is manipulated, it is again from 304A to 304. Let me tell you very clearly. It could go from 304A to 304 because you're manipulating your records. Don't ever manipulate. If he has died, he has died. कोई पार्ट नहीं टूटने वाला. Be truthful in your records. And the records normally, what is done is they are being delegated to some other staff. कर देना या मैं जा रहा हूँ. जो 2 मिनट की जल्दी है ना, मरवाती है. पुलिस को भी मरवाती है, डॉक्टर को भी मरवाती है. So don't ever the last minute जो ये hush है ना, that people want to rush back home or to another call or other OT table. That is detrimental.